We will continue argument this afternoon in Case 11-400, Florida versus the Department of Health and Human Services. Mr. Clement.
Mr. Chief Justice, and may it please the Court, the constitutionality of the Act's massive expansion of Medicaid depends on the answer to two related questions. First, is the expansion coercive? And second, does that coercion matter?
Mr. Clement, can I ask you just a matter of clarification? Would you be making the same argument if instead of the federal government picking up 90% of the cost, the federal government picked up 100% of the cost?
Justice Kagan, if everything else in the statute remained the same, I would be making the exact same argument.
The exact same argument. So that really reduces to the question of why is a big gift from the federal government a matter of coercion? In other words, the federal government is here saying, we're giving you a boatload of money. There are is no matching funds requirement. There are no extraneous conditions attached to it. It's just a boatload of federal money for you to take and spend on poor people's health care. It doesn't sound coercive to me, I have to tell you.
Well, Justice Kagan, I eventually want to make the point where even if you had a standalone program that just gave 100%, the 100% boatload, nothing but boatload,
yes,
it'd still be a problem.
You do make that argument in your brief. Just the standalone program, a boatload of money, no extraneous conditions, no matching funds, is coercive?
It is, but before I make that point, can I simply say that you built into your question the idea that there are no conditions. And, of course, when you first asked it was what about the same program with 100% matching on the newly eligible mandatory individuals, which is how the statute refers to them. And that would have a very big condition. And the very big condition is that the states, in order to get that new money, they would have to agree not only to the new conditions, but the government here the Congress is leveraging their entire prior participation in the program.
Let me give you a hypothetical,
Sure.
Mr. Clement. Now, suppose I'm an employer, and I see somebody I really like, and I want to hire that person. And I say, I'm going to give you $10 million a year to come work for me. And the person says, well, I've never been offered anywhere approaching $10 million a year. Of course I'm going to say yes to that. Now, we would both be agreed that that's not coercive, right?
Well, I guess I'd want to know where the money came from. And if the money came from...
Wow. I'm offering you $10 million a year to come work for me, and you're saying that this is anything but a great choice?
Sure, if I told you actually it came from my own bank account. And that's what's really going on here in part. And that's why it's not simply a matter of saying...
Mr. Clement, can that possibly be? When a taxpayer pays taxes to the federal government, the person is acting as a citizen of the United States. When a taxpayer pays taxes to New York, a person is acting as a citizen of New York. And New York can no more tell the federal government what to do with the federal government's money than the federal government can tell New York what to do with the monies that New York is collecting.
Right. And if New York and the United States figured out a way to tax individuals at greater than 100% of their income, then maybe you could just say it's two separate sovereigns, two separate taxes. But we all know that in the real world, that to the extent the federal government continues to increase taxes, that decreases the ability of the states to tax their own citizenry. And it's a real trade-off.
Limit on the federal government's power to tax?
What's
Are
that?
you suggesting that at a certain point the states would have a claim against the federal government raising their taxes because somehow the states will feel coerced to lower their tax rate?
No, Justice Sotomayor, I'm not. What I'm suggesting is that it's not simply the case that you can say, well, it's free money, so we don't even have to ask whether the program's coercive.
Now, counsel, what percentage does it become coercive? Meaning, as I look at the figures I've seen from AMICI, there are some states for whom the percentage of Medicaid funding to their budget is close to 40%, but there are others that are less than 10%. And you say across the board this is coercive because no state, even at 10%, can give it up. What's the percentage of big gift that the federal government can give? And because what you're saying to me is for a bankrupt state, there's no gift the federal government could give them ever because it can only give them money without conditions.
No,
matter how poorly the state is run, no matter how much the federal government doesn't want to subsidize abortions or doesn't want to subsidize some other state obligation, the federal government can't give them 100% of their needs.
And Justice Sotomayor, I'm really saying the opposite, which is not that every gift is coercive, no matter what the amount, no matter how small. I'm saying essentially the opposite, which is there has to be some limit. There has to be some limit on coercion. And the reason is quite simple, because this Court's entire spending power jurisprudence is premised on the notion that spending power is different and that Congress can do things pursuant to the spending power that it can't do pursuant to its other enumerated powers precisely because the programs are voluntary. And if you relax that assumption that the programs are voluntary and you're saying they're coercion, then you can't have spending power jurisprudence that's different.
What makes them coercive? That the state doesn't want to face its voters and say, instead of taking 10, 20, 30, 40% of the government's offer of our budget and paying for it ourselves and giving up money for some other function, that's what makes it coercive?
Well,
the state is unwilling to say that?
Maybe I can talk about what makes it coercive by talking about the actual statute at issue here and focusing on what I think are the three hallmarks of this statute that make it uniquely coercive. One of them is the fact that this statute is tied to the decidedly non-voluntary individual mandate. And that makes this unique, but it makes it significant, I think. I'll continue. I thought you had a question. I'm sorry. The second factor, of course, is the fact that Congress here made a distinct and conscious decision to tie the state's willingness to accept these new funds, not just to the new funds, but to their entire participation in the statute, even though the coverage for these newly eligible individuals is segregated from the rest of the program. And this is Section 2001A3. It's at page 23A of the appendix to the blue brief.
Isn't that true of every Medicaid increase? That each time, this started quite many years ago, and Congress has added more people and given more benefits, and every time the condition is, if you want the Medicaid program, this is the program. Take it or leave it.
No, Justice Ginsburg, this is distinct in two different directions. One is, in some of the prior expansions of the program, but not all, Congress has made covering newly eligible individuals totally voluntary. If the states want to cover the newly eligible individuals, they'll get additional money, but if they don't risk any of their existing participation programs. The 1972 program was a paradigm of that. It created this 209B option for states to participate. This Court talked about it in the Gray Panthers case. There were other expansions that have taken place, such as the 1984 expansions, where they didn't give states that option. But here's the second dimension in which this is distinct, which is here Congress has created a separate part of the program for the newly eligible mandatory individuals. That's what they call them. And those individuals are treated separately from the rest of the program going forward forever. They are going to be reimbursed at a different rate from everybody who is covered under the pre-existing program. Now, in light of that separation by Congress itself of the newly eligible individuals from the rest of the program, it's very hard to understand Congress's decision to say, look, if you don't want to cover these newly eligible individuals, you don't just not get the new money. You don't get any of the money under the...
Where does it say that? I'm sorry. Where does it say that?
It says that where does it say what, Justice?
What you just said. You said Congress said if you don't take the new money to cover the new individuals, you don't get any of the old money that covers the old individuals. That's what I heard you say.
Right.
And where does it say that?
It says it in — there's two places where it says it. The
where?
2001A3 makes
Where's
part
in
of my
your brief?
That's at page 23A.
In the blue brief.
Blue brief.
23A. Okay. Thank you.
And this makes not the point about the funding cutoff. This makes the point just that these newly eligible individuals are really treated separately forevermore.
Okay. I want the part about the funding cutoff.
Right. And there, Justice Breyer —
that section is what?
I don't have that.
Well, I have it in front of me.
Great. Perfect. Thank you.
I'll tell you what I have in front of me, what it says.
Right.
And it's been in the statute since 1965.
Exactly.
And the site I have is 42 U.S.C., section 1396C. So are we talking about the same thing?
If that is the provision that gives the Secretary, among other things,
and here's what it says at the end.
Participation
it says,
yes.
The Secretary shall notify the state agency, this is if they don't comply, that further payments will not be made to the state or in his discretion, that payments will be limited to categories under or parts of the state plan not affected by such failure, which it repeats until the Secretary is satisfied that he shall limit payments to categories under or parts of the state plan not affected by such failure. So reading that in your favor, I read that to say it's up to the Secretary whether, should a state refuse to fund the new people, the Secretary will cut off funding for the new people, as is obvious the state doesn't want it, and whether the Secretary can go further. I also should think, I could not find one case where the Secretary ever did go further, but I also would think that the Secretary could not go further, where going further would be an unreasonable thing to do, since government action is governed by the Administrative Procedure Act, since it's governed by the general principle it must always be reasonable. So I want to know where this idea came from that should State X say, I don't want the new money, that the Secretary would or could cut off the old money.
And, Justice Breyer, here's where it comes from, which is from the very beginning of this litigation, we've pointed out that what's coercive is not the absolute guarantee that the Secretary could cut off every penny, but the fact that she could.
All right. Now, let me relieve you of that concern and tell me whether I have. That a basic principle of administrative law, indeed all law, is that the government must act reasonably. And should a Secretary cut off more money than the Secretary could show was justified by being causally related to the State's refusal to take the new money, you would march into court with your clients and say, Judge, the Secretary here is acting unreasonably, and I believe there is implicit in this statute, as there is explicit in the ADA, that any such cutoff decision must be reasonable. Now, does that relieve you of your fear?
It doesn't for this reason.
I didn't think it would.
But here's the reason. Here's the reason Justice Breyer doesn't. I mean, one is, I don't know the opinion to cite for that proposition. Second is, we've been making in this litigation since the very beginning this basic point. The government has had opportunities at every level of this system, and I suppose they'll have an opportunity today to say, fear not, states, if you don't want to take the new conditions, all you will lose is the new money. And when
I said because it could be, given the complexity of the Act, that there is some money that would be saved in the program if the states take the new money, and if they don't take the new money, there is money that is being spent that wouldn't otherwise be spent. There could be some pile like that. It might be that the Secretary could show it was reasonable to take that money away from the states, too.
Mr. Clement,
my point is you have to show reasonableness.
Do you agree that the government has to act reasonably? Do we strike down unreasonable statutes? My God.
Well, and Justice Scalia,
the executive has to act reasonably, that's certain, in implementing a statute. But if the statute says in so many words that the Secretary can strike the whole funding for the whole program, that's the law, unreasonable or not, isn't it?
That's the way I would read the law, Your Honor. And if I could just add one thing just to the discussion, is the point that, this is not all hypothetical. There was a record in the district court, and there's an Exhibit 33 to our motion for summary judgment. It's not in the joint appendix. We can lodge it with the court if you'd like. But it's a letter that's in the record in this litigation, and it's a letter from the Secretary to Arizona when Arizona floated the idea that it would like to withdraw from the CHIP program, which is a relatively small part of the whole program. And what Arizona was told by the Secretary is that if you withdraw from the CHIP program, you risk losing $7.8 billion, the entirety of your Medicaid participation. So this is not something that we've
put up.
Mr. Clement,
to make you feel a little better, I want to pursue this for one more minute. There are cases, and many of which Justice Scalia knows as well, which use Holly Hill uses the same word as this statute, in the Secretary's discretion. And in those cases, this Court has said that doesn't mean the Secretary can do anything that he or she wants, but rather they are limited to what is not arbitrary, capricious, and abuse of discretion in interpreting statutes, in applying those statutes, etc. End of my argument. End of my question. Respond as you wish.
Well, Justice Breyer, I'm not sure that the Court's federalism jurisprudence should force states to depend on how a lower court reads Holly Hill. I think that really right here what we know to an absolute certainty is that this statute gives the Secretary the right to remove all of the state's funding under these programs. And think about what that is.
Clement, do you think that the federal government couldn't, if it chose, Congress say, this system doesn't work. We're just simply going to rehaul it. It's not consistent with what we want to accomplish. We're just going to do away with the system and start a new health care plan of some sort. And states, you can take the new plan, you could leave them. We're going to give out 20% less, maybe 20% more, depending on what Congress chooses. Can Congress do that? Does it have to continue the old system because that is what the states are relying upon and it's coercive now to give them a new system?
Justice Sotomayor, we're not saying we have a vested right to participate in the Medicaid program as it exists now. So if Congress wanted to scrap the current system and have a new one, I'm not going to tell you that there's no possibility of a coercion challenge to it, but I'm not going to say
That's
that.
I want to know how I draw the line. Meaning,
well,
I think the usual definition of coercion is I don't have a choice. I'm not sure why it's not a choice for the states. They may not pay for something else. If they don't take Medicaid and they want to keep the same level of coverage, they may have to make cuts in their budget to other services they provide. That's a political choice of whether they choose to do that or not. But when have we defined the right or limited the right of government not to spend money in the ways that it thinks appropriate?
Well, Justice Sotomayor, I'll try to answer that question too, but the first part of the question was, what if Congress just tried to scrap this and start over again with a new program? Here's why this is fundamentally different and why it's fundamentally more coercive. Because Congress is not saying we want to scrap this program. They don't have a single complaint, really, with the way that states are providing services to the visually impaired and the disabled under pre-existing Medicaid. And that's why it's particularly questionable why they're saying that if you don't take our new money, subject to the new conditions, we're going to take all of the money you've previously gotten that you've been dependent on for 45 years and you're using right now to serve the visually impaired and the disabled.
Mr. Clement, may I ask you a question another line? You represent, 26 states?
That's right, Justice.
So we're also told that there are other states that like this expansion, and they are very glad to have it. The relief that you're seeking is to say the whole expansion is no good, never mind that there are states that say we don't feel coerced, we think this is good. You're saying that because you represent a sizable number of states, you can destroy this whole program even though there may be as many states that want it, that don't feel coerced, to say, think this is a good thing.
Justice Ginsburg, that's right, but that shouldn't be a terrible concern because if Congress wants to do what it did in 1972 and pass a statute that makes the expansion voluntary, every state that thinks that this is a great deal can sign up. What's telling here, though, is 26 states who think that this is a bad deal for them actually are also saying that they have no choice but to take this because they can't afford to have their entire participation in this 45-year-old program wiped out, and they have to go back to square one and figure out how they're going to deal with the visually impaired in their state, the disabled in their state.
Mr. Clement, I didn't take the time to figure this out, but maybe you did. Is there any chance that all 26 states opposing it have Republican governors and all of the states supporting it have Democrat governors? Is that possible?
There's a correlation, Justice Scalia.
Let me ask you another thing, Mr. Clement. most colleges and universities are heavily dependent on the government to fund their research programs and other things. And that's been going on for a long time. And